Hey guys. So, as many of you know, although some may not, I've been covering the Maddox versus Dick Masterson lull suit, but there is a concurrent court action between these two parties, which actually started much earlier than this current one. I guess it originally began back in January when Maddox filed for a a trademark of the phrase, or of the mark, I guess, biggest problem in the universe, which is a reference, if you are unaware and uninitiated. It is a reference to the podcast that was hosted by both Dick Masterson and Maddox, starting back in 2014. It's where a lot of the fan base for Dick was built, and where a lot of the fan base for Maddox slowly whittled away until he decided to create a significantly worse podcast following their breakup, and then proceed to make every wrong decision you could think of to offend his fans and alienate the few people who were sticking with him because he used to be funny. As such, Maddox filed for a trademark of the biggest problem in the universe back in January. It went through some procedural issues, and then a preliminary trademark was issued in May, specifically, I think, May 30th, which prompted Dick Masterson to have to respond and assert his own claim of ownership by filing a motion of opposition, which they did on June 27th. You have 30 days from the preliminary mark being issued. Excuse me, from the mark being published to file a motion of opposition. So they were within the 30 days on filing it, and I figured, we could go through these documents. They're not as, in some ways, I should say, they're not as salacious as the lawsuit, mainly because most of the motions come from Dick Masterson's attorneys, and they appear to be competent. Maddox filed the initial documents pro se, meaning without representation, and those are really like they're kind of like click-through forms on the Patent Trademark Office website. So there's not a lot of chance for him to exercise his writer's muscles and be very creative. He just basically pulls down some categories and makes a couple statements. So I'm going to go through it. Let's go through the procedure and get to where we are today. I don't know if I'll finish this all in one video, mainly because once we get out of the form documents and into the actual complaint, or the petition for opposition and the motions that follow, it gets a little bit longer. So let's dive in. And by dive in, I mean I'm going to take a minute and explain something here, because there's not, I guess property law is a weird thing, right? In the United States, we have property rights, and the United States has fiercely protected individual property rights for a very long time. And the cynical among us, self primarily included, would cite plenty of times where the government just tramples on property rights. But for the most part, individual ownership of the products of your labor is protected in the United States, probably more fiercely than anywhere else in the world. For those of you who are curious, I am drinking again Lagavulin 16, which is just magic. Strongly recommend for anyone who likes a very peaty, smoky scotch. It's hard to go wrong. Very smooth. Really not refreshing at all, but satisfying. Wholly satisfying. Sorry for the brief whiskey review. We'll go on. So property law is strongly protected in the United States, and we have a couple different ways to do that. But there's a general misunderstanding amongst, I guess, lay people, lay persons, whatever you prefer to be called. I will respect your pronouns insofar as people or persons is chosen. There's a general misunderstanding in that people think that there is someone who owns a piece of property. And that's an improper way to consider property rights, because you're gonna run into an issue where you think someone owns the property and you're wrong. The better way to consider this, and this is the kind of annoying junk that you have to drill into your brain in law school, is that you're not looking for the absolute owner of property. You're looking for the person with the best claim of ownership to a piece of property, right? Because at any given time, that ownership could change based on new evidence. And an easy way to kind of consider this is, if someone goes into a store and they're looking at products and they set down their cell phone on a shelf, okay? They set down their cell phone on a shelf, and then they leave. Who owns that cell phone? It really depends on the intent of the person, right? Because if the person set down the phone accidentally and left, and they come back and assert their claim of ownership to the cell phone, then they own the phone. That's theirs. They have the best claim of ownership. But they're not the only claim of ownership, because the store could say, hey, this was sitting on our shelf. We were in possession of the phone. We have a claim of ownership. And their claim of ownership may be inferior to the original owner of the phone, but it is superior to someone walking in on the street, seeing a phone on the shelf and saying, oh, no, I'm going to take this phone. The store will say, whoa, that's in our property. We have a property interest or an ownership right in that cell phone. And they do, because if the original owner were to come back to that store and ask what happened to their cell phone, they would be interested in returning it to the person. Now, we won't get into the technicalities of like causes of action and all that stuff, and how you would prove, like, if the store was somehow liable to the owner. That's not really important. The idea, though, is that there's a cascading chain of people with ownership claims, and actually, if we want to get really technical and pedantic about it, everyone has some sort of ownership claim on every piece of property. There's just usually several parties better positioned in the line of ownership. But that's important. So how we determine then who has the best claim is a series of evidence. And that evidence can be common law evidence, which would be people asserting the ownership right and exercising their ownership rights consistently over a period of time, builds up a common law evidence, right? So if you start a business and you run your business under a certain name, let's make it easy. Let's make it simple. Let's go with the lemonade stand, right? But so I go out and I start a lemonade stand and I call it Rekieta Lemonade, okay? And I sit and work this lemonade stand and actually build it up into some sort of community icon where people come because I have a special spiked lemonade that people really like. Probably not a spiked lemonade, right? Because we run into liquor license issues. But okay, so I just have a good lemonade formula. I use freshly squeezed lemons that I grow in my own trees, and then I squeeze that and I give just the right amount of sugar. So I produce this great lemonade. Everybody loves it. Rekieta Lemonade grows. I don't have to file a trademark or copyright or patent to any of the business activities to own them and to establish ownership. If I run Rekieta Lemonade for 5 straight years, and I'm the only person who's using that mark, that moniker, that name, then I have a lot of evidence that I own what's called a common law mark to Rekieta Lemonade. And the only thing that would beat that evidence would be a pre-existing common law mark or a registered trademark that that maybe, you know, that someone filed for the trademark and they provided evidence, and I had a notice and opportunity to contest that that trademark. A trademark gives you basically a very high level claim of ownership. It's not always superior to a common law mark, but you have to demonstrate, if someone has a trademark and you're asserting a common law mark, you have to demonstrate why you didn't properly oppose the trademark in the first place. And there could be any number of reasons. We're not going to get into all those. But I mainly want to express very early on in this process that there are levels of evidence and ownership, and a trademark is a legal recognition of very high evidence of claim to a piece of a property right. So that's what Maddox is trying to do here, right? He's trying to get that legal recognition through a trademark where the United States government patent trade offices issue basically a recognition that he is the owner of this piece of property. And so he has asserted ownership to the biggest problem in the universe. And he did this, January 23rd, 2017. Now there's some technical aspects to this, and I'll get into them a little bit here. But the basis of his filing is listed as Section 1A, and I will get to that in just a second. And he says the first use anywhere is at least as early as May 20th, 2014. That's the first use anywhere, and then the first use in commerce he has listed as November 1st, 2014. Great. And that's he's got it filed under two different categories. Class 009, which covers downloadable MP3 files, MP3 recordings, online discussion board posts, webcasts, webinars, and podcasts, news and audiobooks in the field of entertainment. And then he's got Class 038, which is podcasting services. So he's attempting to trademark not only the podcast itself, but also the MP3 files that are associated with the podcasts, the discussion board. Presumably this would include the voter tallies from The Biggest Problem. And then I would also assume it would include the YouTube live shows that they did and any bonus content. So, so that's under Section 1A. Now, Section 1A is under the Trademark Act, and it's cited and searchable as 15 U.S.C. 1051 A, which is the application for use of trademark. Now, I'll go through this real quick, and I may edit this and throw it up on the screen. I may not. It depends on how late this gets. But this is boring and basic stuff. When we get to the bigger documents, I'll try and throw them up for sure. But the application for use of trademark, this is a couple different sections. Importantly, the owner of a trademark used in commerce may request registration of the trademark on the principal register hereby established by paying the prescribed fee and filing in the PTO an application, a verified statement in such form as may be prescribed by the director. The application, this section 2, the application shall include specification of the applicant's domicile and citizenship. So yes, Maddox's home address is on this because he's wanting to protect himself, but he went ahead and just put it right on the document. Good job, buddy. So it'll specification of applicant's domicile and citizenship, the date of the applicant's first use of the mark, the date of the applicant's first use of the mark in commerce, the goods in connection with which the mark is used, and drawing of the mark. So he has to include a drawing of the logo for Biggest Problem, which he did. He did that. The statement shall be verified by the applicant and specify that A, person making the verification believes that he or she or the juristic person on behalf he or she makes the verification to be the owner of the mark sought to be registered. Juristic person is just legalese for like a corporate owner, because corporations are persons under law. They have the right to sue and be sued. By the way, I'm going to do a video on corporate personhood and how just wrong everybody is on Citizens United at some point in the future. But like, thank the government that corporations are people, because it makes things actually much more efficient in terms of law and how we actually address problems with corporations and how corporations can actually be liable to consumers. So corporate personhood is very misunderstood, and most people who are talking about it are wrong. So that's great. Like everything, most people are wrong about it. Don't listen to them. So yeah, basically the person has to they make a verification that they believe they are the owner of the mark sought to be registered. Now, ownership in this context means sole owner, the rightful owner of the mark. If you have, say, for example, a partnership that owns the mark, and one partner goes ahead and applies for the mark, they're not the owner. The partnership is a juristic person that owns the mark. So one sole owner does not qualify, even if they, have, we'll say 90% ownership through the partnership documents. It doesn't matter. They're not the owner. The partnership is the owner, and they own the partnership. That chain of ownership doesn't translate to direct ownership of the mark, because you can't just cut out a business partner because you don't like them, right? To the best of the verifier's knowledge and belief, the facts recited in the application are accurate. The mark is in use in commerce, and to the best of the verifier's knowledge and belief, no other person has the right to use such mark in commerce, either in the identical form thereof or in such near resemblance thereto as to be likely, when used on or in connection with the goods of such other person, to cause confusion or to cause mistake or to deceive, except that in the case of every application claiming concurrent use, the applicant shall state exceptions. Okay, that's not important. What's really important here is that the verifier is making a verified statement. These are statements under oath that they are the owner and that no other person has a similar claim of ownership or any valid claim of ownership to the mark or to something substantially identical to the mark. Because what they don't want is one person, one group, one entity, whoever, doing a bunch of work over a long period of time to build up the brand, to build up their brand, and then have some other person come in, copy it, and just use it, right? The other thing they don't want is a former member of an organization to leave an organization, partnership, LLC, corporation, whatever you want to call them, to leave that, use the existing contacts and their working knowledge of the product and brand to then create and market some other brand pretending to be this previous one. And there are all sorts of reasons for this, right? If someone makes a very serious and successful product that has a long history of good reviews, good ratings and safety, and then one person breaks off, tries to cut some corners, produces a similar product very cheaply, and tries to use the same name, people are going to trust the safety record of the prior company in buying this product. The government is protecting consumers here. So, summary of this is that Maddox is claiming full ownership of the podcast. He is claiming that no other person and no juristic person, so no entity or other person, has ownership of the podcast. He's doing this under oath, and he's also saying that no other person could or does use the exact same trademark, the exact same mark in commercial use currently that would cause confusion to customers of the alleged owner. All of these are problematic, as I'm sure you can guess. But let's move on. Basically, so this first document was filed, and like I said, this is Maddox claiming ownership of these existing things, right? The podcasting service, the downloadable files, the recordings, the online discussion board posts. So he's actually claiming ownership of the Facebook posts that were linked to the page, webcasts, webinars, and podcast news and audiobooks, right? So he's claiming ownership of all of the existing content of Biggest Problem. Here's the deal. When you claim ownership of existing content, you have to prove the ownership. You have to prove its use in commerce. This is part of the trademark process that everyone goes through. You can't just show some logos and say that the use is in commerce. You have to show it in commerce. Easy way to do this, of course, would be to show some of the marketing materials. It would be to show, some of the I guess the posts, right, on the website. It would be to show a payment page or a Patreon page if one existed, stuff like that. Sponsorship or advertisements. All of these things would show the mark being used in commerce. So to go, to prove this at some point in the future, Maddox is going to have to submit proof that he's actually using the mark in commerce. And this is where we come to our first problem. So the documents he submits are just logos of the biggest problem in the universe, and then the phrase, the biggest problem in the universe. So that's filed January 23rd. Really boring. I'm probably not going to put up the paperwork because there's just no reason to. There's nothing on it that's interesting. But I may show the logo. I'll try and throw the logo in for a quick edit. Whatever. What happens next is where things start to get interesting. Now, we don't know why this happens specifically. But on April 19th, Maddox files a voluntary amendment to his application. And the reason he does this, or the purpose for the amendment, is to change the intended use, or to change the ownership claim from a claim of ownership of existing content to a claim of intent to use the mark in future commerce. Okay, so this changes the requirements of what's needed. Now, as we'll get to in Dick's opposition to this, Dick's legal team speculates, and probably properly so, that a clerk at the Patent Trade Office contacted Maddox and said, listen, the stuff you submitted to us is not sufficient to show use in commerce, right? Use in existing commerce. So you either need to present evidence that shows use in commerce currently, or you have to amend the application to show something different. Like you have to change what's going on, because if you're not using this in commerce, then you can't assert a claim of ownership to the existing use, right? That's the allegation by the Dick legal team, and we'll cover that in the opposition motion. But it's good to get it out here to just kind of start to get your mind around why he would change this stuff. So this amendment changes from Section 1A and changes, and 1B, and let's see, what is it? It changes it from 1A to 1B. So real quick, I won't read all of this, but so the previous section that I read through was Section 1A of 1051, or Section A of 1051. This is Section B of 1051. This is application for bona fide intention to use trademark. So a person who has a bona fide intention, under circumstances showing the good faith of such person to use a trademark in commerce, may request registration of its trademark at the principal register hereby established by paying the prescribed fee, blah, blah, blah. The application shall include specification of the applicant's domicile and citizenship, so that's the same, and a drawing of the mark. And then the statement shall be verified by the applicant and specify that the person making the verification believes that he or she is, or the juristic person is entitled to use the mark in commerce. The applicant's bona fide intention to use the mark in commerce. So you have to make a statement and show, not just a statement, but a showing of some evidence that you intend to use the mark in commerce, like providing marketing materials, maybe a business plan, something like that. And then that to the best of the verifier's knowledge and belief, the facts recited in the application are accurate, and that to the best of the verifier's knowledge and belief, no other person has the right to use such mark in commerce, either in the identical form thereof, or in such near resemblance thereto as to be likely to cause confusion, mistake, or to deceive. Confusion and delay, right? Thomas the Train has told us that is bad. You can't cause confusion and delay with your trademark filing. So Maddox has gone ahead and amended his trademark filing from the original one, which is existing use in commerce, to this new one, which is a bona fide intended use in commerce. And again, all this stuff is made under oath. So we're left with a question. Is Maddox trying to claim ownership of the original show? That would be his original filing. I'm claiming ownership of everything associated with Biggest Problem so far. I will own it. I own everything in the past, and I will therefore own everything going forward. Or, as amended, is he claiming not to own the stuff in the past, not to have any asserted right of ownership, but merely to have an intention to use this trademark in the future, absent anyone else's use of this trademark? That's where we're at now. He has changed from the first method of existing ownership to a bona fide intent to use things going forward. What is he going to use the Biggest Problem trademark for going forward? We have no idea. And this is where problems are going to come in, right? Because Maddox, if this thing gets before a patent trademark board, which has been requested, if this gets before the board, Maddox is going to have to justify with evidence to the board that he has a bona fide interest in using the mark in commerce in the future, and not just holding the mark for the sole purpose of preventing someone else from using it in commerce. That's not okay. You cannot do that. That's it's called a lot of things, but in this case, it would probably be a case of what we call cyber pirating, right? And you see this in like domain squatting and stuff. So some new domain hosting service opens up. There's a big company that we saw a lot of this back in the 90s, but there's a big existing company like Walmart. Someone will go on and grab Walmart.com and then like try and hold Walmart.com as ransom and get a large payout. And some people did because it was cheaper for the companies to pay them out than to litigate against it. But eventually the government decided that this is not an acceptable use. This is basically extortion, right? You're taking someone's existing trade name. You're registering the domain name for yourself for some useless purpose. You don't have any existing use. They have a better claim to the mark than you do, right? And then you're trying to extort money out of them to sell them back the use of the trade name that they built up. The Trademark Office is one way that people tried to create that better claim of ownership, right? So in one instance, you might go register the domain name for Walmart.com and try and hold it hostage for 10 grand or whatever from Walmart. Some people went a step farther and registered tried to register an actual trademark based on this intended use. But if you don't have a bona fide intended use, if you don't have marketing materials, if you don't have some sort of demonstrable plan to sell products in the market under this trade name, that's a frivolous use of the trademark, and that's a bad thing. That's cyber pirating. It's specifically called out in the statutes. I'm not going to read them because that's actually kind of long. But cyber piracy is a no-no. So if Maddox's intent in filing this trademark is merely out of spite to prevent Dick, as a former co-owner of the show, from going out and referencing biggest problem in the universe, presumably to prevent him from daring to utter the name biggest problem on his show, or probably more likely to prevent him from using the biggest problem in advertisements, or targeting fans of the biggest problem on Facebook in targeted advertisements, anything like that. In theory, Maddox would be able to exercise a trademark right over the biggest problem, and somehow attempt to prevent Dick from using the phrase biggest problem in the universe without some sort of license, right? If that's his goal, just to prevent Dick from using it, that's a bad thing. That will not go well for him in front of the trademark board. He has to show an intent to use it. So we have to then, we don't have to do this, right? We're left with the task of trying to figure out what the hell use he's planning on doing. Is Maddox going to relaunch Biggest Problem? I think that's been, that's the intent, I think, of Biggest Debate or Best Debate or whatever that stupid show is to recreate the magic of Biggest Problem. So if that's his motive, to try and relaunch Biggest Problem with a new co-host, but go back to the old format that he and Dick built, he's asserting his ownership. If that's his thing, he's going to run into real problems, because there's an existing mark that does this. So we've got a lot of conflict coming out of George's corner here. We're not really sure, and I'm guessing Maddox isn't sure either, if he's trying to assert ownership of the existing mark or to create a new mark entirely. And this is going to give, the moral of all this, right? And this is why you hire some dumb idiot like me who's awake at 3 a.m. recording himself yelling about law, right? This is the reason you hire a nerd to do this for you. Because what Maddox has done is he's given Dick's lawyers a wide open shot to tear apart his bona fide motive for creating this trademark, right? Had he filed it properly in the first place, and by properly, I mean, had he filed it as amended in the first place, he may have a better claim, except he probably doesn't. He probably should have stuck with the idea that he was the existing owner and tried to tailor the evidence in that way. He didn't do that. He instead amended it to this new thing, which might sink his entire claim to the trademark. To be perfectly honest, he may have no claim to the mark, or no better claim than Dick, we'll say, to the mark, because he's gone ahead and changed this section, and there's an existing common law mark for Biggest Problem in the Universe that presumably, if Maddox started up a new show, it would cause confusion. Dick's legal team addresses this in their opposition document, which we will get to. But more on the procedure. There's a couple more sections here. So that was April 19th. The next document is April 21st, basically the approval of the amendment. And it's important to know that at this point in time, the trademark office has not had the trademark board go through and review this application yet. They actually assign a trademark attorney, and that trademark attorney starts to look for issues. So at best, some guy has looked for issues, said this looks okay based on just the information given. This acceptance of the amendment is not actually any statement that the amendment is valid. It's that the amendment process has been followed appropriately, right? This has been, the drop-down menus have been clicked appropriately, and submit has been done, and fees have been paid. That's what has happened on April 21st. And there are several documents showing all of that, the same thing. We're not gonna get into that. The next major action that happens here is May 10th. This is a notice of publication. So this would be a notice sent to Maddox, and it basically states that in the next issue, assuming no one files, no one files a motion of opposition in a timely manner, this is going to be published in the next trademark patent official gazette, where they'll post the initial publications of all trademarks and patents that are granted. This will be done on May 30th, absent someone coming in and challenging it prior to that. And you don't have to challenge it prior to that. Okay, like that's... Most parties can't really challenge it prior to that. Most parties wouldn't know until publication. At least that's how the court views it, right? Publication in the PTO Gazette is how people are given notice. And so their time to respond runs from the date of publication, not from the date that notice is given. So notice is given on May 10th, and then on May 30th, the Trademark Official Gazette has been published, and notification is sent to Maddox that this has been published. And this document is very boring. It just has some links to the actual notice of publication. The relevant section of this document is very short. It's a significance of publication for opposition. And I'll read this because it's only a couple sentences. Any party who believes it will be damaged by the registration of the mark may file notice of opposition or extension of time therefore with the Trademark Trial and Appeal Board. If no party files an opposition or extension request within 30 days after the publication date, then 11 weeks after the publication date, a notice of allowance should issue. Note the applicant must file a complete statement of use or extension request with the required fees within 6 months after the notice of allowance issues to avoid abandonment of the application. Okay, so a couple things are happening here. So it states that any party who believes it will be damaged may file the notice of opposition within 30 days of the publication date. So in this case, published on May 30th, that means that the 30 days later is June 29th. That's the time that Dick has to file his motion for opposition, or he has to file a request for extension. They're supposed to grant a request for extension upon showing of good cause that it's needed. Doesn't matter. They filed on June 27th, so their filing was timely, and everything's good. The next part of this about the notice of allowance is that, so 11 weeks after the 30 days, or 11 weeks after the publication date, if no opposition is filed, you have to prove that you're actually using the trademark in commerce, right? Because Maddox has filed a notice of intent to use it. So had Dick not filed, he would then have 11 weeks to show its use in commerce to prove that his intent was genuine. And if Dick should fail at challenging the trademark, Maddox will have 11 weeks after the resolution of the motion to go ahead and file this notice of file proof that he's using it in commerce. If he does not, he will be forced with abandonment of the patent. So his patent isn't actually like sealed until 11 weeks after all of the action is done, and then he also has shown by preponderance of evidence that he is using. I shouldn't say by preponderance of evidence. I assume that's the standard, more likely than not, that he has a bona fide interest and is using that interest. Or he files an extension. You can file an extension, you can get it up to about 24 months if you can show cause for why you haven't used it. And there's a lot of reasons people wouldn't use a trademark within 24 months, right? It takes a lot of time and planning to build a brand. You might have a killer idea and you want to nail down the brand and you have every intention of using it in commerce, but 11 weeks might be too fast for production. You might run into delays like Kendall and Hyde, right? Like how Kendall and Hyde just never sent out products to several of their customers because they ran into delays which we like to call stealing money from people. But if you're like Kendall and Hyde and all of your leather sources just disappear because you can't possibly find a cow to skin, then you can't deliver products to people. So you might apply for an extension there, just so that you can maintain the trade name, maintain your interest in entering your trade name into commerce, but you run into some sort of mechanical or logistical issue that prevents you from doing it in a timely manner. So that's where Maddox's actions leave off for the time being. This video is getting a little long. I apologize for the cut. I accidentally stopped recording after saying it was getting a little long, and it is. I could do, I could go on for another probably hour going through this, but I think I'll break it up into a couple videos because there's no reason to go through this all tonight. The videos will come pretty quickly because the documents exist. The one thing I'm kind of waiting for, and I'll see if I can publicly source them. I've got to see if I can find the emails that were filed, because they were filed publicly. I'll see if I can get them. I don't know if I can get them, but if I can get a hold of the emails, I'll see if there's anything significant in them. I'm not going to promise to read through them as some sort of goss thing. That would be funny, but we'll see. I'm more concerned on exploring the legal issues here and finding out if if those emails have any probative value to Maddox's claim. I doubt it. And if there's any way I can go ahead and publish them, I'm gonna publish at least significant portions of them because they're public documents. But currently they're not available, so we may have to just wait for a ruling from the Trademark Trial and Appeal Board on specifically whether these emails can be included as evidence or not. We'll see. What's interesting is these emails may be submitted elsewhere as evidence, right? That may happen in the near future. I don't know. I'm not on Dick's legal team, but it's possible that those emails may show up in a concurrent lawsuit. And if they do and are public, I will absolutely be discussing them probably on both this in the context of the trademark and then in the context of the lawsuit, if they have any probative value in either one. So we'll see. But what has happened since Maddox is done filing, and this is what we'll cover very soon. Dick has filed. First, he filed his opposition, as I said, on June 27th. He filed the motion for opposition. Notice and trial dates were set, and Maddox had to answer by a specific date. Actually, it says that Maddox's time to answer was August 6th, and Maddox's answer comes on August 7th. I haven't done the math to see if that's right. But if it's wrong, that'd be really funny. There's a discovery conference that happened on September 5th. And the discovery opened on September 5th. Initial disclosures were due by October 5th. And then if there's any expert disclosures, those are due February 2nd. Actually, this is interesting real quick. I'm going to read this timeline because I want you guys to realize just how freaking long this crap takes and why it costs. I mean, trademark and patent stuff costs a fortune. And that's funny because Maddox is going to bleed out on this stuff. We don't know what Maddox's advertising revenue is, but we know that Maddox and The Best Debate don't have a Patreon that's comparable to Dick's. So if he's and Maddox has now retained counsel. That's another thing that's happened in here. He's retained a lawyer for the trademark thing. So if Maddox is paying for 2 lawsuits, right? He better have a fortune. he better have a fortune. We can infer with some sort of accuracy Dick's income from the Dick Show Patreon, right? We know that Sean gets a portion of it. We don't know how much, and that's fine. But we know roughly what they're working with, and if we can take some percentages of that and make hypotheticals. But think about, when I go through this, think about how much this stuff costs. Okay, so time to answer. August 6th. Deadline for Discovery Conference, September 5th. Discovery opens on September 5th. So Discovery Conference is where you get together with the other attorney and you decide if there's anything that's definitely off limits or irrelevant. You maybe talk about, you develop a discovery plan, because sometimes when you have multiple servers hosting content, for example, getting all of those documents and all of the contents organized in a way that's searchable and viewable by the other party, that can take some prep work. So you have a discovery conference to plan out and stipulate and agree on when you're going to turn things in. Discovery opens September 5th, right after the conference. Initial disclosures are due October 5th. There's probably some statutory initial disclosures that I'm not going to go through because this is really technical. But you make some initial discoverable things. If you're going to talk to any experts or whatever, you have to disclose their name. If you have any witnesses that you know have knowledge of this, you have to disclose their name and contact information. If you have any statements from those witnesses, you have to disclose them. That's your initial disclosures. Then you've got expert disclosures due February 2nd of 2018. So that's if you have an expert, their statements have to be sent to the other party in advance. You can't you can't surprise people in court like on TV. All of this stuff, unless it's really rare circumstances, all of this stuff is known to both parties in advance. Sorry to spoil the magic. Discovery closes on March 4th, 2018. So we're still in discovery until frickin' March of next year. Plaintiffs' pretrial disclosures are due on April 18th of 2018, and the 30-day trial period ends on June 2nd, 2018. Defendants' pretrial disclosures are due June 17th, 2018, and defendants' 30-day trial period ends on August 1st, 2018. Then the plaintiff gets a rebuttal, which is August 16th, and then the plaintiff has a 15-day rebuttal period ending on September 15th. Then the plaintiff's opening brief, if this goes to trial, right? If this goes to oral argument at trial, the opening brief is due on November 14th. The defendant's brief is due December 14th. And the plaintiff's reply to the defendant's brief is due December 29th. We're over a year out without a resolution. And then you can request an oral hearing on those briefs on January 8th of 2019. That's the schedule. We'll see if it goes that long. I can't imagine Maddox can afford to keep paying 2 lawyers for likely a year. This stuff costs a fortune. Tens of thousands of dollars to do this, to carry it to term. I'm guessing that there's no way Maddox dumps the money into this. And I think, as just a simple matter of tactics, and this will be up to Dick and his legal team, as a simple matter of tactics and knowing or being able to roughly estimate the income of Maddox, he can't afford this. And as long as Dick's income stays strong, there's no reason for him not to keep pursuing this, because he stands only to lose if he doesn't pursue it. If he pursues it, he stands to gain, he can continue to receive income and to market the mark for biggest problem. Oh, excuse me. And that doesn't necessarily mean he's going to generate income from views or listens or downloads for the biggest problem. And he can't sell ads. I guess in theory he could try, but it's not going to be beneficial to sell ads on the existing podcast because downloads have sharply dropped off since the show ends, right? That's okay. But His ability to continue referencing The Biggest Problem as a prior work project that he was associated with and co-owner of, very important. His ability to market to Biggest Problem users, very important. And really important in the lawsuit is that if Dick makes a showing, like, and this is, I shouldn't say really important. It's not really important because the whole claim is frivolous in the lawsuit. But if Dick can show in the trademark office that he is co-owner of Biggest Problem in the Universe, as we obviously, any fan of the show knows that this is a joint venture, right? Everybody knows this is a joint venture between the two co-hosts. This is not Maddox hosting Dick. You learn that basically immediately. If you had a converse assumption, it's shattered right away when you start listening to the show, that Dick is a co-equal partner here, or at least a significant stakeholder, right? Like, if you want to make a really an evidence-free argument, as Maddox is wont to do, you could maybe say that Dick is a 20 to 40% owner of the show. Maybe. That's only if you listen to Maddox in an extremely biased way and ignore all other things that Dick is bringing to the podcast. If you just say, well, Maddox had a bigger fan base than Dick, so maybe he owns 70% and Dick owns 30%. That doesn't matter, right? 30% ownership of a partnership. The partnership owns the mark, not the individual owners. So it's kind of crucial for Dick to defend this. If he can show any percentage of ownership of a general partnership that owns the mark Biggest Problem in the Universe, he immediately weakens Maddox's claim of conversion in the lawsuit, right? Because Maddox's claim is that Dick took property of Maddox, which would be, I guess, rights to the fan list from The Biggest Problem. If Maddox is a sole owner of Biggest Problem, he could maybe assert that his customer list is some sort of protected trade secret that he owns under the trademark. I don't think this is a successful argument, mind you, but that is an argument, at least, which is better than what he has going for him. If Dick prevails on the trademark, Dick significantly weakens Maddox's position on at least a couple causes of action on the lawsuit, if not all of it. Assuming attrition is a thing, and we can at least estimate Maddox's income based on ad revenue. We can go and look at the 4 or 5 people who are viewing his videos. We can look at his Patreon, which is barely above mine, which is, Maddox, buddy, it's a little sad. By the way, if you want to, as a funny measure of spite, donate to my Patreon simply for the purpose of bypassing Maddox, I'm not going to complain. I'm with it. This is a good plan. That's patreon.com/lawsplaining. Please check me out. It'll be linked in the description as always. I don't like to pimp it, but if it's funny to lay it out there as spite for Maddox, then let's do it. His Patreon's barely above mine, so you know he's not making a ton there, and you know that his ad revenue, like, we can actually kind of estimate his ad revenue based on downloads, because that's how you do it. It can't be solid. He alleges in the lawsuit that he's getting he was getting at the time 40,000 downloads per week. I'm betting it has significantly dropped since then, but let's just even carry that forward. We can estimate his weekly income when he has an advertiser based on what he said about Harry's, and we should probably take it and probably have it, because there's no way advertisers are paying for that kind of exposure to his dying audience. But what Dick can ask, my point in all this, and I'm sorry, rambling because I'm drinking liquor. It's really late at night, and I'm just chatting with you guys. Dick can estimate with some level of accuracy Maddox's income, because Dick knows what advertisers pay. Right? He was part of The Biggest Problem. I guess if we pulled up the spreadsheets that were publicized a long time ago, we could probably do the same thing. So all you got to do is figure out download numbers. You look at Patreon. You figure out Maddox's other sources of income, which F Wales is probably generating him, like $15-20 a month in sales. Good job, buddy. And we can pretty much figure out that Dick is making a ton more money than Maddox and can probably outlast him legally. If that's the case, it's only in Dick's interest. And that was a really long way. Like a 15-minute... I just spent 15 minutes telling you what I told you at the end of the other show, that it's in Dick's interest to keep this going. It's only going to cost a fortune for everybody involved, but Dick wins in the long run. Dick wins the battle of attrition. So I hope this little bit about property rights and procedure in the trademark process has been a little bit informative, mildly entertaining. I hope. There's more to come. The next video I will be discussing Dick's motion of opposition, and we'll hopefully catch up. I don't think the emails will be publicly available prior to the next video, because I really want to have it out in the next couple days here, not to leave you guys hanging for a week or anything like that. There's no reason to. So we can do that. We can do the review of those other documents and then get to the emails when they're brought back to the public. And we can talk about, Dick has also filed a motion to make all of that confidential stuff part of the record in public, like not confidential, because it isn't. He's introducing it as evidence, and you have to have some good reasons to make it confidential, like trade secrets or account information, stuff like that. Anyway, like I said, hope you guys enjoyed it. Thanks for watching. More to come on this, more to come on the lawsuit, and I appreciate your support. And we'll have some other non-Maddox versus Dick related content coming in the next 2 weeks or so here. So, see you guys around.